Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for the Patent 300 for patent preparation and prosecution. If you enjoy this podcast, please share it with others and leave a 5-star rating. And now here's your host, Eli Mazur.
Today we're lucky to be joined by the legend of the patent bar, the virtuoso for Federal Circuit Court decisions, and the mentor of all mentors, Tom Irving himself. When a friend of mine, a former Finnegan alum who's a little shy, but is one of our most successful Finnegan alums there, he saw you were leaving Finnegan. He said, "You got to interview Tom Irving. He'll be the best guest of all time." So I'm excited, and thank you so much for doing this.
You're very kind.
And I want to actually start with a quote from one of the people that you mentored. I got to tell you, over the course of this 1 week where we scheduled this interview, every other person I talked to, they either met you in law school, you were mentored by them at Finnegan, somehow they met you through professional organization. The number of attorneys you've touched is really quite amazing. But this is Anita Varma. She's now the chair of Whiting Cases IP Groups. This is what she said about you. As a junior associate working with Tom, I was always struck by the depth of his knowledge and his passion for the law. Tom is an incredible reservoir of case law, and he infuses the same passion and enthusiasm for the law and junior associates that he works with. And if you've ever been at one of these big IP conferences and you somehow wandered into what you thought was going to be a very boring panel about Federal Circuit decisions, and you hear this very excited voice who's could be talking about anything and you would be listening, it was probably Tom Irving. So thank you so much for doing this.
Oh, thank you. You're very kind.
You actually started practicing, I believe, over 47 years ago, before the Federal Circuit existed.
That's true.
So you've seen it all, and now we see some very exciting news out of the Federal Circuit where Chief Judge Moore she wants Judge Newman to retire. What do you think about all that's happening?
Well, I don't know the facts, but I'm a big fan of Judge Newman. I mean, who isn't? And so I don't know the facts, and they'll do an investigation. I heard her say publicly the other day she thinks it'll turn out okay. I wish her the best. Many of the women in our profession stand on her shoulders. She was the chief patent counsel of FMC in Philadelphia in the 70s, Eli, when no women had important posts in patent law. Yeah. So I'm a huge fan of hers. Okay, she dissented against me in Chen versus Bouchard, but nobody's perfect.
Let's talk about your career. Can you tell us when you first learned about patents? Do you remember when you first?
I do. I was in law school at Duke University, and I looked around, and I realized I was the only person there with a STEM background, and the rest of them were all smarter than I was. So I thought, wait a minute, what could I do? And then I found out that this thing called patent law existed, which was perfect for me. So I discovered it during law school.
And why did you think it was perfect for you? Just because of your tech background?
Yeah, because I had this degree in chemistry, and then I liked the law, even in law school, I liked the law. Yeah. And so I thought, this will be great. This is probably something I can make a living at.
And you're originally from Utah?
I am.
And you live there now. It seems there's a lot of patent attorneys in Utah and from Utah. Is that because they all met you, or is there something else? I
never quite understood that, but it is a very productive area for patent attorneys. There's a lot of great attorneys practicing there, and then a lot of people move away, like I did, for 47 years or so. So it's an interesting anomaly, but I believe it is probably disproportionately represented from the population of Utah. There's a lot of patent lawyers.
Do you think it's something about the culture or the practice of patent law that kind of makes it a good fit?
I wonder. I know when I grew up there, I went to high school in the 60s, STEM was important. Yeah. Even back then, and I think a lot of people got interested in STEM, and then, they found out they could get into law school, and it was a natural.
You being from Utah impact your practice?
Well, first of all, it got me into Duke University because I was a product of affirmative action. They wanted geographical distribution. I said, hey, I'm from Utah. That's pretty diverse, and they let me in. So I thought that's what put basically my foot in the water into Duke Law School. I've been ever grateful.
So you finished Duke Law School. How did you end up at Finnegan?
Well, what I did was I figured out, as I said during law school, I wanted to be a patent lawyer. So I applied after my third semester, I think, with this little firm called Finnegan, Henderson, Faribault, and Dunner. And they seemed very excited that I had applied. And they said, oh, well, you can come up and start in January. So I got a leave of absence from Duke. I went to American University Night School for that semester, stayed up with my class, and that's how I got in at Finnegan. So I started there in the profession in 1975, and it was great.
And how little was the firm?
10 years old.
And how many attorneys do you remember?
Oh, yes. I think there were 18.
Okay.
It's changed. It's a great firm, and they've really grown and evolved and done well. Yeah. But it was pretty small when I started.
Your background is in, I think you have a chemistry degree, but you've been in biopharma most of your practice. When you joined Finnegan, was that kind of your path? You're going to focus on biopharma patents, or was it? No,
not at all. I joined Finnegan, and they were trying to teach me how to do mechanical claim drafting.
Yeah.
I had no facility for that. I thought, whoa, it's going to be a short internship. But then I discovered chemistry, and I knew more about chemistry than the other people in the firm did. So I quickly became the chemical expert. That was a niche I was able to fill.
Do you have any long-term goals in the beginning besides, getting through that internship?
My long-term goal was not to get fired. And that goal never went away, Eli. I always thought it was good to be looking over your shoulder and say, well, I really would like to continue to do this and not get fired. Yeah. But I was hoping I could one day become a partner, and I did. And that was just a wonderful experience. And what Finnegan was absolutely wonderful. For 47 years and 4 months, I loved it there. I mean, the time came, it was time to go. And the Marbury made me an offer I couldn't refuse. And so I'm happy to be here because I do practice. I intend to practice till I die in 2054. So there's a good long while. I figured that's way too long for Finnegan.
You said, Finnegan was getting cases, pharma cases, and you were the best one to handle them. So it seems like there wasn't a deep bench of pharma background. What was like the pharma patent practice at the time like that? Was it?
It was tiny. Yeah. I thought what really accelerated the pharma patent practice was Hatch-Waxman, which came in '84, and then all of a sudden became a big deal. Also, when the Federal Circuit was instituted, all the general practice firms said, hey, that looks like an interesting area, and they began to expand into patent law, and that has greatly benefited the industry. When I took the patent bar, 200 people a year passed the exam. I think now it's 1,000 a year. Yeah. So it's just really become something that people can look forward to. You in patent law use their STEM background, and it's just a wonderful way to make a living.
So what's interesting, what you're saying is the general practice firms getting into IP litigation or patent practice and pharma practice, it was actually a good thing for patent attorneys because it grew the field instead of taking the work away, I guess, from the specialized.
Absolutely. Yeah, I guess one wondered at the time, well, what happened to all these general practice firms? But it was a great coexistence. Yeah. And it really was a benefit to the profession to have the general practice firms come into the patent law.
And did you ever think about joining one of them, one of those general practice firms?
No, I like too much Finnegan and still like Finnegan. It was great. It was smaller, and everybody I could talk to had a STEM background, so I didn't need an interpreter. It was great.
Yeah. Well, actually, take us back to the pharma. There's a lot of controversy about the cost of drug prices and all that. What was the thinking like at the time, I guess, when you started practicing about innovation in that field, about the cost of drugs and all that? What was like
I never heard the cost of drugs mentioned. Yeah. It was never mentioned because as they developed more and more sophisticated drugs, they became more expensive. Yeah. But I never heard that in the early days. And so the feeling towards pharma was, oh, these are great clients. They got interesting work. It's meaningful because they're trying to get patents that cover products they'll get approved by FDA. So it was a pretty accepting environment back then about pharma.
And you mentioned how the Hatch-Waxman Act was one of the things that kind of spurred the growth of that practice. Can you talk a little bit more about that? why specifically the Hatch-Waxman Act?
Oh, it was a big deal because before Hatch-Waxman, there was this Roche versus Bolar case. And that case said you couldn't experiment at all. If you were, say, in a generic drug manufacturer and you wanted to make a product, it was patent infringement. And so Hatch-Waxman came along, had numerous compromises. And one of the compromises was that, well, we'll have this Hatch-Waxman, the generic can essentially certify against the patent, then the drug holder had, I think it was 45 days to bring suit. And then that was where I really became aware of generic manufacturers because they began to take advantage of the challenges, which I don't know why I should complain. That spawned a whole industry of litigation and work and even more interest in pharmaceutical patents.
Back then, did you have to kind of decide, am I going to represent the pharmaceutical company, the innovators, or the
Eli, that's a great question. I don't remember when that occurred, but I remember it did occur. And there were some law firms that seemed to be able to represent both. It never worked for us at Finnegan. And so we were representing the brands, although what happened was after AIA, you started to get IPRs and PGRs, which can be brand versus brand, and so that sometimes you're even going against a brand, but usually on behalf of a brand.
Yeah, it's interesting these days because obviously there's some generic companies that start acquire, I guess what you would call brand drugs, and then their minds change about some of the issues.
Some of the issues, yes.
Can you take us back to those first Hatch-Waxman maybe litigations? Anything that kind of sticks out to you? Any big cases or anything like that?
We handled at Finnegan the first Hatch-Waxman litigation, and the party we represented is Zeneca, which through mergers has become AstraZeneca, and nobody knew. Nobody knew at the time what a big deal this would become. And then I thought it was a great benefit to Finnegan's practice to get involved in the Hatch-Waxman litigation, and there was a lot of it, and it was high stakes, and it really, it just accelerated, I thought, the practice. And many, many law firms, I think, were able to grow substantially because they were either representing the innovator or they were representing the generic. It was like a whole new area of business opened up.
So that was cool. So you got to work on that first Hatch-Waxman
the Zeneca
litigation
case,
So you were kind of like creating the roadmap for future litigants.
It was so interesting, yes.
Yeah. And anything stick out from that experience about?
I think the main thing that sticks out is that, as I recall, we won.
That's always good.
And
the bills got paid, I imagine, as well. So.
For sure. You never know. You never know if you're going to win or lose because there's always unpredictability in litigation. But we were fortunate to win.
I know before when we were planning this interview, you mentioned that one of the things that you did in your career is help startups with developing and growing and so forth. Can you talk us about that work? How did that kind of fit?
That's the greatest thing because I always liked startups. I always thought the whole concept of IP and social justice, which I'm an advocate of, startups sometimes don't get the representation they need. So we were fortunate to get some startups. And these are the people I really admired, like Agaron. Oh, they were running a business. They were paying payroll. They were paying our bills. They had no product. I thought, these people are geniuses. How do they do this? And so we worked hard on their patents. They had patents on Viracept. They'd acquired the rights, I guess, in part from Eli Lilly. And so they got these patents on Viracept. And son of a gun, when they got ready to do due diligence, they were acquired, and it's in the public record, but I believe the press release said it was something like $2.1 billion in 1999. That was a lot of money in 1999. And so I think most of them went off and bought Greek islands and it got bored after a while and went back to work. But that was very fulfilling. I was very pleased with that deal. And then I got to work also other deals like Principia Biopharma, little startup out in the Bay Area. And we got involved with them early on, and they got good patents. And oh my goodness, they got acquired by Sanofi. And Sanofi thought it was also important. And it's mainly in the pharma area, patents drive it. That's really the main asset that you're acquiring. So I'd have to look at the press release, but I think that ended up like $2.8, $3.3 billion. So clearly, they were very happy with how their patents came out.
You mentioned that you worked on the first Hatch-Waxman litigation, and then you were helping these startups. I mean, how did working on that litigation kind of inform your thoughts about how do we get these valuable patents for these startups?
Well, I realized, along with many others, I'm no genius, I realized that, wait a minute, these pharma patents are really important. And then they had, the Orange Book. And so if you could get patents or either active ingredient, drug product, method of treatment, you could list them in the Orange Book. Yeah. That was great because then they had to certify, the generics had to certify, and then it became a game of how strong is your patent? Yeah. And if you had a strong patent, and the nice thing was you only had to win on one claim and one patent to be able to maintain your market position. Okay. So it became just an art form. Working hard to make sure, we'll make, no patent's perfect. I haven't seen the perfect patent yet. You try to make it as strong as you can. Yeah. Because the generics, they're good at coming after things, as they should be. And so you got to have a good, solid asset to be able to defend your product.
Yeah, and I think that applies outside of pharma. It's really about having a strong portfolio of patents, not don't put your eggs in one patent.
I believe that's correct. I believe that's correct.
These days, you hear a lot of controversies surrounding some of the strategies that pharmaceutical companies use to build their portfolios in terms of filing a lot of continuations. They call them patent thickets and all that, whatever the derogatory terms of it they are. What do you think about all that, all these complaints and...
Well, what I think, representing a bit of pharma, I've always felt that if I was able to obtain a patent, and of course, because of inequitable conduct, you got to be totally straightforward. Yeah. You got to really be transparent. But if you could get the patent, and it passed 101, and it passed 102, and it passed 103, and it passed 112, I didn't worry about the other things. Obviously, double patenting's been a big deal in pharma, and so you have to deal with that. But I always, and again, this is my biased view based on my experience, was, patents are good. And if you can get them and list them in the Orange Book, and you obtain them honestly and truthfully, well, that's wonderful.
You mentioned the AIA and how that came into practice. I remember when the AIA PTAB was created, the post-grant proceedings, some were worried and some were hopeful short sellers on Wall Street that they could, easily challenge pharma patents at the PTAB and get them invalidated and cause the stock prices to drop and all that. And it turned out to be not a foolproof strategy, to understate that. And it's very different from what's happened, obviously, in other tech areas. Why do you think it is? Why do you think it's been so much more difficult to invalidate pharma patents than, mechanical patents or...
Yeah, I don't have the stats, but I always thought one thing was the pharma company had laser-like focus on what it was they were going to get approved. Yeah. And so it's bizarre. I grew up back in the 70s saying, you want to get a broad patent claim. Well, with Amgen versus Sanofi and cases like that, breadth can be a problem. Yeah. But with the laser-like focus on the product that you actually are going to get approved, I just found it was easier to basically hone the patents to those products. And then because they were laser-like, they tended, I was reading today, there was a decision, Amgen versus Sanofi, came out today, and it dealt with apremilast. And I thought that Amgen didn't do it. It was Celgene, and they bought it. It covered Otezla. But they did a good job. Yeah. They did a good job, and the claims were narrow enough. They didn't have a lot of written description, enablement issues, and they won on 2 of the 3 patents. They won on the stereoisomer patent. They won on the crystal patent. And I think the one they lost on was the dosage regimen. Yeah. But in a way, what did they care? Yeah. They had their drug product, they had their drug substance, and it came out really well. And it was clear to me, didn't have anything to do with the case, but reading the opinion today while you were coming over, very carefully done with the patents. And I thought the people that litigated on behalf of Amgen did a marvelous job. It wasn't us. So it's not like I'm, lauding Marbury or lauding Finnegan. No, it wasn't. But boy, they did a good job and really adduced the facts and all the legal theories I thought they should have done, and won 2 out of 3, which is a big deal.
Obviously, this is something that patent attorneys and applicants in other fields are learning now, post-AIA, post-PTAB, that broader does not necessarily mean better. Sometimes it's worse. It's actually better to have as narrow claim as possible if it's going to read on what's out there. But in pharma, that was already the case when these companies were obtaining patents. They knew what they needed to cover. They didn't need to cover broader than that. And
Eli, that's exactly right. And so you'd start with the narrow, and then there's the end action. Then there's a 505(b)(2) action, where, for instance, the generic will use some different active ingredient. They have to show it's bioequivalent stuff. So I've always thought, you need your narrow to basically hold your own in the ANDA litigation. And for 505(b)(2), you need a little bit of flexibility. You need a little bit of breadth. But I like to have that little bit of breadth in a different patent. So they're not all schmozzled in there together. So that's kind of a fun thing is, well, what breadth can you get? And then I discovered, and I really pushed this. My first mentor was P.J. Federico, who wrote the 52 Act. What a guy. And he said in 52 that, they started 112.6 and it was means plus function. He said, this could be used for chemical compositions. And as best I could tell, Eli, nobody used it for about 40 years. And then I got the idea, this could be good because by statute, the claim covers what you link it to in the spec and equivalence thereof. What kind of equivalence? Literal equivalence. You don't have a Festo problem? So I pushed that. It took a while to get the patent office to accept that. They've now accepted that in many areas, and those are valuable patents. And so I'm thinking, wow, those are great because they look narrow, but they're maybe not as narrow as they look because this idea of literal equivalence, what does that mean in a given case? I have no idea. But I know the one decided case on this, the Walkenhardt case, is settled. They say, you're not going to learn anything with settled case. But what happened was in Walkenhardt, they settled. The alleged infringer accepted a permanent injunction. I thought, woo! I thought, there's something here, because if they're willing to accept a permanent injunction as a condition of settlement, there's something to these patents. So that made me even more excited about them.
But do you think anything about that there's more respect for pharma patents than other types of patents? If the AIA was going to invalidate a pharma patent, it might cause some serious instability and harm the way invalidating a patent for some toy might not.
I don't know. A lot of those toys, I have 7 children and 16 grandkids. A lot of those toys, Eli, they're incredible. Incredible toys.
No, I don't mean they're not incredible, but is there a level of deference, respect given to pharma patents that isn't given to other types of patents?
That's a great question. I don't know how to answer that question. All I know is that a fair amount survive. They come through, and they're sustained. For one thing, they kind of look complicated because generally it's a molecule.
You're talking about the pharma patents.
The pharma patents, yeah. And somebody can say, that's just a toy. You could do this. The pharma patent, it might be a little bit more difficult to say that.
Yeah.
And maybe that's a reason. Could be.
I've long thought that sometimes very simple, elegant ideas, which a patent attorney, at least myself, could not come up with it, but a very smart person came up with it. But when you look at it, you're like, oh, of course.
It's the hindsight. It's the hindsight. Yeah, you get a judge like that and say, I could have done that. Yeah. Anytime the judge says that, you're in trouble.
So you're saying that, when you started in the practice, there wasn't much talk about the cost of drugs and so forth. And it seems like these companies started investing a lot in research development. A lot of great drugs are coming out, curing all kinds of diseases that you never thought possible before. Did you see that change in the atmosphere, kind of politicians becoming more antagonistic and people becoming more antagonistic towards big pharma and so forth? Well,
I've certainly seen that over the last few years. There seems to be a considerable antagonism towards big pharma. And I always thought in my naive way, these people don't understand. These are drugs that save your life. Yeah. And if we're going to cut off big pharma, are new drugs going to come along to save your life? Maybe not. Yeah. So I've never bought in to the antagonism. I'm grateful for the prescription drugs I'm given, and they do sustain and make my life better, and I appreciate that.
Do you think there's something that people don't appreciate about why drugs cost so much? From your experience, from working with all these startups and bigger pharmaceutical companies, that you kind of can share that?
Well, it seems to me, and again, this is just empirical experience, it seems to me that there are a lot of failures before you get a hit. And so you can invest a lot of money. And I think generic companies probably dispute that. But it seemed to me, hey, people can be pouring a fortune into all this, and they're finally going to get a hit. Yeah. And so with that hit, then they want to be able to protect their product and all. Now, are drug prices too high? I have no idea. I'm not an economist. But enter the insurance industry, which is, I think, in my view, it transformed the practice of medicine. And if you've got good insurance, it's great, but that bothers me that many people don't have good insurance. And so what do? Go for the drug that's really expensive, that maybe they just don't get the drug. And I think that's tragic, because these great drugs, I like to see them as available as possible.
And in your way, you devoted your life to the patent system, to helping these innovators who invest billions of dollars in pharmaceuticals, making sure that they get a return in their investment. When the whole pandemic happened, there was a big push to waive all those patent rights. And the U.S. government signed on with that idea. Maybe it didn't have a practical effect, but it had at least, it sent some kind of signal. What did you think of it?
Well, as a believer in patent rights, I didn't go wholeheartedly in favor of these waivers, but I could see where the government, and I think it was not just one party or the others, both parties, where they thought, hey, we got a real problem here, and we need to get this drug out to people, and we don't want patents standing in the way. But I think it came, it went. The pandemic, as near as I can tell, is over at this point, and I think it's back more to normal. But in anything like war, natural disasters, there's sometimes emergency measures taken that you wouldn't take in the absence of war or emergencies, but you take them because it's a way to benefit the populace.
In the beginning, I mentioned your enthusiasm for cases, and it's really a sight to see. I hope every patent attorney gets a chance to see you once, kind of go through all the court decisions. Even during our conversations, you've brought up probably more cases than I can keep in my head. Can you tell us, how do you follow all these cases? Do you read every single Federal Circuit decision? How do you keep track of all?
Well, being a pharma guy, a pharma person, what I focus at mainly, because I looked at the cases that were decided today, and I thought, Amgen versus Sandoz. Oh, I got to read that one. So I kind of pick the ones I think they're going to involve pharma, and then focus on those. And the mechanical electrical, I got partners here that are incredible. They understand all about mechanical electrical. I thought, they'll figure that out. My job is to do what I'm supposedly good at, which is to figure out the pharma cases and how they apply.
Do you usually read the decision itself or the summary? I
read the decision because I don't believe in summaries. I believe you need to read the decision. I mean, that Amgen versus Sanofi case today is amazing for the breadth of issues. And I've seen a couple of summaries of it. That doesn't do it justice. So I like to read the decision itself, which I think for patent lawyers, okay, you have to have the time to be able to do that. You have to have the inclination to do that, but I sure find it useful.
Can you talk about it? How do you find it useful? So Federal Circuit gets a lot of flack for coming to different decisions depending on what panel is hearing the case. How do you decide, well, this panel came to this decision. Is it really, should I advise my clients to adjust what they're doing based on this one decision or not?
Well, that's really an issue, because anytime a panel decides something, then I figure, well, if it doesn't go en banc, and they don't go en banc very often, it is kind of the law that governs the USPTO. And so I try to look at it, and I try to do exactly, Eli, what you're doing. Tell the client, well, there's this Amgen case. It came out today, and it says that you could get a stereoisomer, and it would be patentable over the racemic mixture, which is scientifically thinking, how could that be? But the Amgen developed wonderful evidence, adduced wonderful evidence. They sold the whole thing. And so I would say to somebody now, oh yeah, don't give up on that. You've got this isolated stereoisomer over a racemic mixture. Let's look at the facts of Amgen. And can we match those? And let's try to match them as carefully as we can. And then can I guarantee a result? No. You never know what's going to happen. But that would put yourself maybe in the best position.
I was looking at a video of you doing one of these CLEs. and you brought up a Supreme Court case that I don't think had anything to do with patents.
Chavez.
Yeah,
Chavez.
yes. And it had to do with the fact that whether the Article A means one or more, and you somehow knew that would be important. Can you share how does your mind work? How do you...
Well, some people would argue it works very poorly, but you look at it, and I've always thought it's a question of kind of grammar and syntax. So if I say, "Oh, I'm claiming a widget," but then somewhere else, I'm claiming one or more rubber stoppers in the claims. So I thought, wait a minute, if when I meant one or more, I said one or more. So when I said A, there's a good chance it means one and only one. It's like consisting of one and only one. And so I try to apply that and have people think very carefully about using these indefinite articles, a and and. And I thought this recent case that found that the a was in a very specific context, Salazar. I believe
Salazar versus
Salazar. But what they found was that it was really the way the invention was written. I think they were making the wrong argument. They wanted to say, well, there's this certain element, and it does this and this and this and this. But then they want to say, wait a minute, one element doesn't have to do A, B, and C. You could have two elements. One could do A and one could do B and C, which I thought was illogical, and so did the court. And so I've always believed, Eli, that one of the things I love about patent law, I'm not too worried about AI replacing us, is it's the thinking person's profession. And I don't think that these computers can think nearly as clearly as you and I can about all the possibilities. And that's why I find it so invigorating. That's why I want to retire from Marbury in 2054, because this stuff is addictive. And, you look at everything and, ooh, what about that? How does that go? But I thought Salazar was a great wake-up call to the profession that, hey, these things make a difference. Because a lot of people laughed at me when I started the Chavez case. Right. But no, these things are meaningful, and they have meaning in our field. So I was telling people that when Chavez came down, said, hey, that's going to get applied in patent law. And son of a gun, it did.
Yeah, and it didn't take long. How do you apply something like that to practice? You don't want to overreact, right? Because at the end of the day, if you say a widget in a claim and somebody infringes and they have multiple widgets, hopefully that claim with a widget will read on it. But in a situation like Salazar, where you have processors doing something, there it makes sense, but it's a very unique situation. Do you always say one or more these days, or what?
No, I always think about it. I think that's the key thing. It's a thinking person's profession. And I think you want to think about it and say, well, what's the invention here? And I think Salazar was criticized by the Federal Circuit, written by Judge Stoll, who I will never criticize. I was her law partner for 16 or 18 years. But she's a genius. But she said, well, what Salazar wants, they want A to mean at least one of many different things. And it didn't make sense to me. And so I think going at it simple-mindedly is probably the best way to do it.
You mentioned that you actually were partners with one of the judges on the Federal Circuit.
That's right. She's a genius.
I'm sure you know a lot of them. You hear a lot these days, especially about, the Federal Circuit was created to strengthen the patent system, or at least create predictability in the patent system.
Uniformity and predictability. That's what they told us when they were putting it in.
And I've interviewed Judge Michel and Judge Rader, and they said, yes, that happened back in the day, but no longer. You've observed it as long as they have. What do you think? Since you weren't on the court and you're not responsible for those decisions at the time.
No, what I think though is it's become more complex, and I think just like I've always tried to teach the people I mentor that it's a thinking person's profession, it's a thinking person's court, and I like the fact that they look at things, and so I don't even know what uniformity means because every invention better be different, right? Or it wouldn't be patentable. And so it seems to me every opinion, every situation is sui generis, and you have to look at it. So again, those of us who are fortunate enough to draft patent applications and prosecute them, think. Think about what the implications are of the words you're using in the draft.
And this area of law that I'm more familiar with, Section 101, one of the knocks is not only do they come they reason in different ways, these different panels, but they don't even bother addressing each other's decisions. Do you think that's an issue?
Well, the 101 I've never understood. I learned a long time from a practitioner named Richard Kilworth. He used to talk about 101 when it wasn't an issue, and he'd say, "Oh, you got a question about what the utility is?" So he would take out his keys, say, "Throw it on the lawn. If it dies, it's an herbicide. If it grows, it's a fertilizer." I relied on that for 20 or 30 years. So it's become very complicated. Yeah. And it's so complicated, Eli. Fortunately, I don't have to deal with that much because, drugs and stuff, it's pretty clear what their utility is. But I think it's very difficult to articulate. It's become so convoluted that even trying to get legislative help, not a guarantee.
Even putting the 101 aside, do you think a Federal Circuit panel has a responsibility to address decisions related to that area of law?
Well, that's a great, because remember, it's like a constantly expanding universe. Yeah. And so the decisions that were, when I started in 1975, were very few compared to what there are today. Yeah. And so the person that is helping out the judge and the people that are briefing the case, you have page limits in these briefs. How many cases can you discuss? Yeah. And I have a sense, it's a little bit of a gnawing sense, that people are looking at the most recent cases. Yeah. But one of the great secrets of U.S. patent law was the old CCPA, the Court of Customs and Patent Appeals, which had been gone for 40 years. The first time the Federal Circuit sat in South Corporation, they said, we adopt en banc authority all CCPA decisions. So I love to pull those out because, hey, these are en banc authority, and very, very few of them have ever been overruled. And so I guess it's an advantage of being old. There must be one, at least, advantage to being old, is you remember all these cases. You say, wait a minute, we ought to look at Wertheim 1, and we ought to look at these other cases and see how this works out, and what that brings to bear on the modern situation. Yeah. And when cited, if you go into the MPEP, it is full of cites to the CCPA. And so I try to do my best to get that brought forward into analyses that a court or an examiner is going to do to bring these cases forward and not treat them like they were the Dead Sea Scrolls.
Do you think Federal Circuit judges have a responsibility to, it's difficult to make it uniform and predictable, but do they have a responsibility to try to work together to reach that goal? Or should they just really be deciding, the case in front of their panel and wherever everything else?
I don't know. I'm a believer in all facts and circumstances. Yeah. So I kind of think that a Federal Circuit panel should look at the case before them. Go find out, what relevant precedent they can. Yeah. But it's the case before them. And they are not a legislature. Right. They were not called upon to, enact the AIA or to make everything uniform. So I kind of think the way they're doing it is fine.
But at least more en banc panels, would that be good?
No, because my experience is en banc panels, sometimes good, but sometimes not so good. And you just don't know. I almost think you're better off with the panel decision, and then you see what happens, and then you're going to basically, if the person that loses, it's so unfortunate. Yeah. But you're hoping that, particularly in these big money areas like pharma, that they have pending applications, continuing applications, that they could go in and try to fix the reason why they lost. Yeah. I've always believed that means plus function, there's some cases that have been lost that I think could have been won with a means plus function case. They wouldn't have run into enablement and description and the problems they had. So I think all of us have a responsibility, whether it's judiciary or we humble practitioners, to try to bring the best law to bear so that the most accurate decisions can be reached based on those facts.
And not so hidden advice in there, particularly for pharma. Never let the patent family die, right? Keep it alive.
I think that's important. I think that there's cases you don't want to have people writing emails saying, whoa, let's delay this, let's do a continuation. No, the D word should not be used. Yeah. I've always felt, well, things are changing. Unlike, property law or maybe domestic relations, the patent law seems to be a little bit of a different view every time. So I say, well, why don't you keep a case alive so that we can fully protect your rights.
Yeah.
And I think those are magic words. You never use the D word. Say, yeah, things are changing. Let's see what's going to happen.
You mentioned PJ Federico.
Yeah. PJ Federico, what a great guy.
And you said he was your mentor.
Yes.
Can you tell us who he was and how he became your mentor?
Well, he was at the PTAB for years, and then he was the director, and then what was called the PTAB, the board.
Yeah.
And then he and Judge Rich got together and wrote the 52 Act.
Yeah.
And so that was, to me, absolutely incredible. So they wrote it in 52. Then I come into the profession in 1975 working for Finnegan. And so the first thing I ever did was I presented a public paper on old cases. And he got a copy of that paper. This was before the idea of electronics. Right. I put a bunch of copies at the back and somebody gave me a copy. So he calls me up and says, Mr. Irving, this is PJ Federico. Why? I thought I'd heard the voice of God. I mean, yeah. Wow. Yes, sir. What can I do for you? He said, there's a couple of cases that would have made your article even stronger. I said, what were they? And he told me what they were, and then you'd go look them up in the books because there weren't any publications in. But
and what was he doing at that time?
He was, it's interesting, he was of counsel for what used to be called the Cushman firm. Okay. So I thought it was very kind of him to call up somebody that was working with probably considered a competitive firm and help me out. I never forgot that. Yeah. I never forgot his kindness in helping me and helping me see more broadly. And it just really inspired me to learn the law and to try and do the very best I could.
Did you have any other people like that stand out that kind of mentored you?
Oh, I did at Finnegan. Finnegan is such a great place. I mean, the names, Herb Mintz comes to mind, the late, great Herb Mintz. He was an amazing mentor. He had clerked at the CCPA. And then another one who's a contemporary, but I've always considered a mentor, is Charlie Lipsey. He'd clerked for Judge Rich. I always thought, my own biased view is that Judge Rich has been the greatest patent judge we've ever had. Even better than Judge Newman, if you can think of that, because she's amazing. But these people had insights, and they would just come up with things. They say, oh, yeah, but what about this case? You got to go read this case. Okay, I'm on it. Yeah. And then you go read the case. It was wonderful.
You've become, like I said, a mentor to so many patent attorneys. Was that natural for you, or is that something like others were mentors to you and you thought it was important? How did happen?
I don't know, but I've sure enjoyed it. Mm-hmm. I guess I've mentored thousands of people, and I've really enjoyed it. And maybe it's part of like giving back, or what do they could use the phrase paying it forward. I think that it's been enriched my life. I hope it's helped the people I tried to mentor.
Some advice about how do you do the work we do better? That's kind of easier to mentor people on. But sometimes, people need advice about bigger issues in terms of career path they should follow and so forth. Can you talk about how do you think about, giving somebody advice like that? Because, it might have a big impact on them. I don't know. Does that
Well, it's scary because any advice I give is worth what it costs, which is probably zero. But I think it's good for young people to think about what I want to do. Yeah. And, you get the big divide. Do I want to be a litigator? Do I want to be a prosecutor? Well, what do you like to do? Yeah. Where do your strengths lie? Should I be with a private law firm? Or should I be with a corporation? Or should I be with the government, like a great institution like the USPTO? Right. So, well, you got to think about what are your goals and what do you want to do? And we had a lot of people from Finnegan who, when PTAB was formed, went over and became judges. Right. I mean, we have scores of people there that are Finnegan alumni who are now deciding these cases. Now, when they went, they said, well, we want to be able to control our lives more. But with the volume of cases, I really wonder. It's like, the old joke, oh, yeah, they told me I'd work from 9 to 5. You say, did they say 5 a.m.? Did you figure out what that 5 meant?
I hear it's pretty good over there, but
but they work hard. They work hard, and a lot of cases, and it's just public servants, I call them, and I appreciate them all.
Now that we have this unique opportunity to get hopefully spread your advice to thousands more people through this podcast.
Oh, at least 20,000 people, Eli, listen to you.
So I want to, get some of your advice. One of yours, think about what you like to do and kind of deciding the path there. Well, let's say, first-year associate, he's just starting out a firm. in patent practice, what advice would you give him for like kind of succeeding in that first year?
Try different things and try not to get pigeonholed.
Yeah.
Try different things. And also, I always thought the first year associate and even the 47th year associate like me, you need to think about the people who are giving you work as your clients. They're your clients. So you really want to find out how you can help them reach their objectives in a legal, well-reasoned way.
Yeah.
And I think if associates can do that, then they can decide, oh yeah, I tried that. I like this much better. And then they can focus their practice towards that. I mean, one of the things that probably amazes you and still amazes me is how mobile our profession is.
Yeah.
I mean, here I am for 47 years. I got to eventually start over here with a smaller firm, many fewer conflicts. It's incredible. So I think all the way through the career, if people think about what they're doing and, would this be better for me? And ask those questions. Those are good questions.
Yeah. And I'm sure you've seen a lot of people make decisions and maybe some people regret those decisions. What advice would you give? And you said the career is much more mobile. People don't stay with a firm their whole career like they used to. What advice would you give to somebody who's thinking about, well, should I move to another firm or should I?
Well, I think it's a good thought, but I think it's pros and cons.
Yeah.
First of all, I always grew up in the 50s hearing the grass is always greener on the other side of the fence. So it is. But think about all the benefits you have in your present job and what it does for you, and then try to look objectively. And if you're going to go out and interview, which is great, try to ask the probing questions, talk to other associates. Somebody told me today at lunch that she interviewed with some firm, and in the afternoon, a couple of the associates escaped and came to her and said, do not take a job with these people. Oh, she said, well, I got out of there as quick as I could. Not a ringing endorsement when current employees bad talk it. I know the way Finnegan did it, and I bet they do it the same way here, they tried to always make sure the applicants, if they're applying to be an associate, got to speak to other associates and could really find out the lowdown on what are pros and what are cons.
You mentioned that you're not going to retire until 2053.
2054.
2054. You love this. I can tell that, and everybody can tell that. But some people don't love it as much as you. What advice would you give to somebody who's been doing it for a while and, they want to find the same love, maybe that excitement that they had at one point for the work? Any advice for them?
Well, retire. I mean, because a lot of people are very happy in retirement. They're doing things they want to do. A lot of volunteer opportunities to serve people when you're retired that maybe you're too busy when you're doing the regular job. So I think people should always be looking out and saying, well, what do I really want? What's my objective in 10 years? And if their objective in 10 years is to retire and do community service and help out people, work in soup kitchens and stuff. So I didn't tell you, what I'm going to do in 2054? When I retire, I've already got it set up. There's an incredible Japanese restaurant in Bountiful, Utah. It's called Fuji Sushi. I've already arranged with the owners. I'm going to come volunteer for them. And I'll do whatever they want, and they'll feed me 2 meals a day. So I think that'd be a great retirement when I retire from the law.
That's a good plan. My takeaway is not everybody's meant to be Tom Irving.
Thank goodness.
But a flip side of that, how to stay relevant in the patent field. You do what you do, and the field changes, but you obviously want your name out there. You want people to think of you when they have legal problems and patent problems. Any advice about that?
Yeah, you do what you do. And this podcast is a wonderful means of communication so people can know what you do and know your strengths and all that. And I think just it takes, the commitment, which is not always easy in life. People have family pressures, they have health pressures, there's all kinds of things. But if you're able to do it, stay as current as you can. Because I think that helps people stay relevant. They're thinking about what they want to do. They're thinking about, I could do this. It'd be a little bit better. I think that's all good.
Big part of being successful in this field is bringing in work, right? If you're a partner at a law firm. Any advice about that? What have you seen that works for business development? Any kind of wisdom in that area?
Well, what I've seen this works, it's worked in my own life, is really great, and now it's so easy to do. I mean, these podcasts, as soon as you do this, I'll put on my LinkedIn, I did this podcast with Ely Mazur, and you can find out about it. And, they can tune in, get a subscription, and find out about it. But writing articles, and it's so easy now. You just write an article, publish it on your website, and then you can have everybody in the firm repost it on their LinkedIn. It's so easy to do that now. And then I think what people like when I'm dealing with people, there were a couple of people, I'm trying to help build even greater the biopractice here, biopharm. And so I go to these people that I'd like to have them consider us for work. So what do I do? Why did you consider me for work? Well, they're not going to do it on looks, that's for sure. So I always try to send them something.
That's why you have that sharp suit, right?
Yeah, there you go. What a fortunate thing, people can't see this. But I think if you've got something to give them, they say, it's just not a cattle call. They're just not saying, we want to do work for you. But, here's some stuff I did, and here's some things, and this may interest you. Yeah. I think that helps. Okay.
And you mean like an article you wrote or something like that? Yeah.
An article you wrote, a podcast, any kind of thing that you've done is very useful, I think. That shows, as you just said, shows what you're about, shows what your capabilities are. That can't be anything but good.
Another part of this practice, especially if you're on the litigation side, there's a lot of fluctuations, right? You can hit a streak, get a big case, get referred to another big case, and all of a sudden you have a lot of big cases, and then they all settle or go away. How do you deal with that mentally or persevere through that? Kind of how does that?
Well, Finnegan almost came undone in 1978. I think they had 3 major litigations. They all settled. Holy cow. So we're all looking around. I wonder when they'll fire me, because they all settled. Yeah. And yet they kept going, they kept plowing, and then the firm became what it is today. But I think people have to realize no client, or hardly any clients, will be with you for life. Yeah. Sooner or later, there'll be a parting of the ways. The acquisition, you'll do something they're not quite happy with, they'll do something you're not quite happy with. And so I think the idea is to stay relevant and to stay out there. And I just think LinkedIn, to me, was a great discovery that you can do LinkedIn and you can flash all this stuff out there. And when I announced I came to Marbury, astonishing. I wrote a little thing about LinkedIn. I got a new job, and then Marbury did a post and reposted. I got 22,000 impressions.
Wow.
That's not what I'm used to, but that really.
You're an influencer. That's
wow. Then you say, and then I got this thing, I think it's LinkedIn Premium. So you actually see the people who have liked it. Yeah. And then maybe I could talk to them and say, well, you like this, and here's something that could be helpful to you. So no, I think it's just astonishing to me. I don't know much about computers. I started with a manual typewriter at Finnegan, but I certainly have learned that I guess people call it social media, and the only one I use is LinkedIn because I find that very useful for business. Yeah. Wow, it's a good deal.
All right, well, thank you for all that wisdom. Is there anything else, that you want to leave the listeners of Clause 8 with?
Have fun. Life is too short to be miserable. So find a spot where you can have fun. And then if you're having fun, it'll be good.
Great advice. And thank you so much for doing this and for joining Clause 8.
Thank you so much. What a pleasure. I'm flattered.
Thank you for listening to Clause 8. If you enjoyed this episode, please share it with others and leave a 5-star rating. I'd also like to thank my firm, Harity & Harity LLP, for their generous support. Clause 8 is produced by Great Feeling Studios and Brick Brewer. For more information, visit voiceofip.com. Thanks for listening.